Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein. I'm the founder of the GTA family law firm, Feldstein Family Law Group. Both myself and the entire office practice exclusively in the area of family law, and we have offices located in Markham, Vaughan, Mississauga, and Oakville in order to assist you. Today's special guest is one of our associates, Lauren Harvey, and welcome to the show again, Lauren.
Thank you, Andrew, for having me. I'm happy to be here.
So today's topic is actually a really interesting topic, and it's one that many family law lawyers are not that familiar with, which is the validity of foreign divorces in Ontario. And I know Lauren's familiar with it because we've worked on files with this topic, and sometimes when you work on it, other lawyers seem to be completely not understanding what the issues are, what to look for, what not to look for. And some lawyers, in fact, can very quickly make fatal mistakes in these kind of cases that are highly problematic and prejudicial to their clients. So I say that to the viewers, that if you're thinking of arguing a case that deals with multiple jurisdictions, you really need to ask the lawyer you're interviewing whether or not they have experience in dealing with these kind of cases. If they don't, or they seem to give you a blank stare, they're the wrong lawyer for you, because you have to have experience and familiarity in order to deal with these things, in order to avoid some of the pitfalls. So today, Lauren and I will attempt to provide some clarity on that issue, and specifically what laws applies in this situation, and how a valid foreign divorce can impact the legal rights in Ontario, and how a family lawyer can help. So Lauren, what can you tell our viewers about the general legal process involved when someone is challenging a foreign divorce?
So, as you said, Andrew, I'll just reiterate what you said. It is a very tricky area of law, and like you said, very easy to make a fatal mistake. So I agree with you, kind of getting legal representation, or at least understanding the law around it, is absolutely crucial. Because we need to keep in mind that not only will Ontario law, Canadian law maybe apply, but the validity of the foreign law under which that foreign order was made may also be a consideration that a court here would look at. So you need to have an understanding of kind of the law in both jurisdictions. Essentially, the process is, if there is a foreign divorce order in another jurisdiction, it ultimately depends upon whether the order was actually made or not. So, for example, Andrew, you and I have discussed this before. A party here, if there's proceedings in another jurisdiction, could bring what's called a non-suit motion here in order to stay the proceedings in the other jurisdiction. And the reasoning for that could very well be that there are, and I know we'll get into this later, there are certain implications if a foreign divorce is obtained in another jurisdiction. There are certain rights and obligations that a party may not be able to pursue here under Ontario law if that happens. So it's very, very critical to understand the process of where this foreign divorce is at in order to understand what the next steps there are. When we're talking about the Divorce Act, for example, any proceeding for a divorce, an Ontario court has jurisdiction to hear the proceeding if either spouse has been what's considered ordinarily resident in Ontario for at least a year preceding the start of that proceeding. So the question is, does an Ontario court maybe have jurisdiction at that point to even order the divorce based on where the parties were living? In terms of the legal proceeding, the first step would be, if you're trying to challenge it, is if it hasn't been made yet, you want to stay the proceeding in the other jurisdiction.
I want to slow you down for 1 second, because we're going into why we may want to stop and how to stop the foreign divorce. But what I don't think our viewers necessarily appreciate, I want you to answer this, is what is the significance to a case when someone does get a foreign divorce in another jurisdiction? How does it impact them here in Ontario?
So one example, is if somebody obtains a foreign divorce in another jurisdiction, you lose certain rights under Ontario law. For example, you can no longer claim spousal support under Ontario law. So the implications of that foreign divorce could have very catastrophic consequences for a recipient, or who otherwise would be a recipient under Ontario law.
And there's a second piece to that as well, which is child support, that if the foreign divorce has made an order for child support, that may also impact the ability to obtain child support here in Ontario It's a little bit more muddled than it is for spousal support because there's ways around that. But one of the things our viewers need to appreciate, and the following comment really depends on the lens that you're looking at things through, and that is, if I'm a payor of spousal support, Ontario is typically not a good place to be because the numbers are higher than most jurisdictions, if not just about all of them. Quite frankly, when I've dealt with these cases, I've never seen a case where support was less in a foreign jurisdiction than it is for a support payor in Ontario. So from an Ontario support payor's perspective, this isn't a good place to be. From the recipient's perspective, it's a really good place to be. So it's important that our viewers understand the significance of that, because if I'm a payor and I have a foreign divorce, or I want to get a foreign divorce, depending if it meets certain criteria, that may be a really good thing in my case. So now, Lauren, I hand it back to you now that our viewers understand the background, why we have this issue. You were talking about the foreign divorce and how to oppose its recognition.
Right. So there's different ways to oppose it. There's a certain number of grounds that a court would refuse to grant a foreign divorce. So we'll go over maybe a few of them. So one of them is if there was evidence of fraud or unfair forum shopping in obtaining that divorce. So forum shopping is an issue we see sometimes where, for example, one party may not like the law as it pertains to their scenario in one jurisdiction, and so they start to commence a proceeding in a different jurisdiction where they believe the outcome may be more favorable to them. Ontario courts do not look positively upon that. It doesn't necessarily mean every time someone starts a proceeding in another jurisdiction, it's forum shopping. There are valid reasons for starting a proceeding in a different jurisdiction, but the court will consider whether there was any fraud. For example, was someone untruthful about certain residency requirements in that other jurisdiction so that they could get the proceeding heard there? Or was it clear that they were just trying to avoid certain rights and obligations? So that's one thing a court will look at. They're also going to look at whether if recognizing the foreign divorce in Ontario would be consistent with the principles of natural justice here in Ontario. So one of the things that we look at under this head is, was the other party provided appropriate notice of that divorce? So when we look at the Ontario court system, anytime you're bringing any sort of action in court, whether it's a simple divorce or an application, the opposing party, the other side, needs to be properly served with that, whether it be by way of a process server or a lawyer admitting service under the family law rules. Whatever the process is, they have to have formal notice. That proof of service has to be filed with the court. So what a court is going to look at is, the courts understand the proper service requirements may differ from jurisdiction to jurisdiction, but what they're looking at is, was that person properly notified, however is required in that jurisdiction? So what Andrew and I know tell clients is, try to comply with what Ontario would consider to be proper service. Have a process server serve them, have an affidavit of service done, try to do whatever you can to make sure that that is brought to their attention so that there's no dispute later that they didn't know about it, which could be a reason for the court refusing to recognize the divorce. Another reason the court will look at is, if we recognize the foreign divorce, would it go against Canadian public policy for any reason? Another one is if the foreign court or the other authority that granted the divorce didn't actually have the jurisdiction to do so. So, for example, if it's required in that jurisdiction that the parties lived there for a year, let's say, and the parties did not in fact live there for a year, and the court, for whatever reason, whether it be maybe the person lied about how long they had been there, if the court didn't actually have the authority to grant the divorce under their own rules, a Canadian court might refuse to recognize this. So that's why it's very, very important that you're following both the rules of Ontario and also the rules of the foreign jurisdiction if you're getting a divorce in a different jurisdiction. But also it's important to recognize, if you're challenging a foreign divorce, what different grounds you can rely upon. Is it contradictory to Canadian public policy? Is there evidence of forum shopping? Was there proper notice given? So those are all things, not necessarily a full list, but things that the court will consider in determining whether they will recognize it.
So there's some things I want to add to that I think are really important, because you touched on certain words like public policy. Some people may be of the thought that, well, if that jurisdiction doesn't provide for spousal support, that would be against Canadian public policy. And the Court of Appeal has already ruled on that and said, no, that's not the case. So people who are thinking if they're going to a jurisdiction that doesn't have the same views on women, the same views on support, the same views on the equality of both spouses in terms of a relationship and things, well, that may not seem like it would be in accordance with Canadian public policy. Well, you may be very surprised to find that there are lots of cases where the courts have said, yes, that's a valid foreign divorce, and yes, the spouse can't get any spousal support as a result of that foreign divorce. So that takes me down to really what the most important question is that if you're the lawyer on a file and you have a client who you've started an application, you're thinking about an application, and they come to you and say, my spouse just served me with an application in this other jurisdiction, what do you do in that situation?
Immediately get a lawyer in that jurisdiction would be my first advice, or somebody who knows exactly, because for example, we can only advise you what the law is in Ontario. If you're served with an application, you have to respond within 30 days. You need a lawyer who's familiar with the laws in that jurisdiction. Is there an opportunity to respond? What is the timeline to respond? What is the process to respond? And the best way to challenge those proceedings is to get in and challenge them prior to the divorce being made, because once the divorce has been made, you're then challenging the validity of an already existing order, which you need to do in that jurisdiction the court has held, which may be more challenging than challenging an application or a request for an order. So getting a lawyer in that jurisdiction would be step one.
Okay. Now, as part of that, I totally agree with the step one, because you may be able to stop that divorce. You may be able to stop it on the jurisdiction saying, we don't even live there. We haven't lived there in 15 years.
Yeah.
We would rather do it in Ontario. Depending on the jurisdiction, they may say that makes sense. Now, one of the first steps we always do, or in our office, is we want to have a discussion with the foreign lawyer, because the first thing you want to ascertain is this better for my client to take place in that jurisdiction or worse? Because too many lawyers have a knee-jerk reaction of saying, I want to oppose that jurisdiction. Because we just talked about the favorability of support payors and support recipients in Ontario. Believe it or not, some people are really motivated by the fact they can get a divorce quicker because they may have a new partner. They may want to remarry. So I've had the support payor come into my office and say, this person who would be the support recipient has started a divorce application in a foreign jurisdiction. What should I do? I want to hire you to go get the divorce, Mr. Feldstein. And I'll typically say, well, I'm happy to get retained to speak to the lawyer in the foreign jurisdiction. But my very strong gut feeling, it's not an opinion, but retain me so I can speak to them. But this is probably the best thing that could happen to you. Look up at the sky and say thank you, because you just got a massive gift and you're going to do nothing. And that may be the best move. And it's maybe shooting myself in the foot, but that person doesn't want to be here. So we have to establish, like Lauren said, hire a lawyer in that foreign jurisdiction. The two lawyers should have a discussion. You may need the client to help translate it, but you want to find out strategically what's best. Then let's say, for argument's sake, we find out that client, their spouse has started that application in the foreign jurisdiction for divorce, and it's in one of those places where we have a long-term marriage. They're living here in Ontario for a lengthy period of time, and this is going to have significant impact on this person's receipt of spousal support. What do you do then?
Sorry, Andrew, can you clarify that once more? I just want to make sure I understand.
What would you do if the application's been commenced in the foreign jurisdiction? You've hired the lawyer there, but you're concerned about this application going through at some point, and it's in a place that isn't very friendly to spousal support, and we act for the recipient of spousal support.
You'd probably, so if the application has been commenced, you'd probably want to bring, well, like we said before, what's called a non-suit motion to try to stay the proceedings in that jurisdiction, on the understanding then that you would be proceeding with an action then in Ontario, which might be the more appropriate forum. But again, that's only if the order has not been made already. If the order has been made, it's a different question.
So this is where the whole theme is. These are not issues that when you get served and your spouse says to you, as an example, you know what, if we get the divorce in Ontario, we have to wait a year. There's jurisdictions where it may be 3 months wait, 6 months wait, maybe even no waiting. And people want to go ahead and say, well, let's get the divorce quickly so we can move on with our life. you have to realize your spouse may be playing you where there's real significant economic consequences that may be long lasting. Because in that scenario I gave you of a 20-year relationship, and I say 20 years very clearly because Lauren knows exactly what that means.
Yeah,
Lauren, if you want to tell our viewers.
Yeah, so we in family law, there's a rule, like an informal rule, but enforced. It's called the Rule of 20, which essentially states that if the length of the parties' relationship, which can include marriage and premarital cohabitation, or for common law couples, just the period of cohabitation, if the length of the relationship is 20 years or more, the support recipient, if they can prove entitlement to support and they pass that hurdle, they can actually be entitled to what we call indefinite spousal support. And that doesn't necessarily mean spousal support for the rest of their lives or the rest of the payer's life, but it means that the court may not be willing to put a stop on the spousal support. It would be indefinite, subject to a review. Which could be, depending on the age of the parties, could be a significant number of years before either party reaches a circumstance in their life that they would be able to seek a review of the spousal support for. So, like, for example, a common material change we see is, for example, when somebody reaches the age of 65. If parties have been together for 20 years and they separate when they're 50 years old, they still have 15 years potentially before they can seek a review, depending on if there's other circumstances that would warrant other reviews prior to then. But you could potentially giving up a lot of spousal support if you can prove entitlement and you have sought a foreign divorce.
Okay, so I think our viewers are getting our message of this is not a sit back and relax moment. This is the proactive moment. And I'm going to ask you the flip side of the question now. When will Canadian courts recognize the foreign divorce?
So if we look at the legislation first, and then we'll look at the common law. So Section 22(1) of the Divorce Act states that Canada will recognize a foreign divorce if either former spouse was habitually resident in that country for at least a year preceding the commencement of the proceedings. However, the legislature doesn't stop there. If we go down to subsection 3, it actually says that nothing in this section prevents the upholding of common law principles that are applicable to foreign divorces. So just because somebody was not habitually resident in that country for a year preceding the commencement of the application doesn't necessarily mean an Ontario court will not recognize the foreign divorce. It just means we look to the common law then. And what the courts have said in the common law have said that they will recognize a foreign divorce where the parties had a real and substantial connection with that foreign jurisdiction where the divorce was granted. For example, this could include the periods of time that they lived there. Do they have family there? Do they have property there? Do they have bank accounts there? Did they live their life as a married couple there? Were any of the children born there? Did they have citizenship there? Did they have residency there? Did they have licenses there? All those types of things are things that the courts will consider in determining, did these parties have a real and substantial connection to that jurisdiction? And if the court says, yes, they do, then a Canadian court could very well recognize that foreign divorce, despite the fact that they may not have lived there for the last year.
And that's really important. And there isn't a set list or a checklist. There's a whole bunch of factors they can look at. Another one is, did they get married there? Did they have bank accounts there? There's a whole host of them. And the reason why we're saying that, what they're trying to stop is, I picture the scenario where somebody had citizenship in a country because they were born there. They immigrated to Canada when they were 6 months old. Their whole family is here. They've never gone back to the old country. They have no real connection to it other than the fact they lived there for the first 6 months of their lives. In the last 40 years, they've been in Canada. But they heard about this law and they thought, wow, I'm going to go for it. I mean, even better, maybe their parents were born there and they got citizenship that way, and they've never set foot in that country. You could see how that would seem like someone is trying to jurisdiction shop so that they could say, we want to stop and prevent spousal support. And what the case law is telling us is that's not really going to fly. That's not really going to cut it. At least that's my gut feeling, subject to what I see judges seeing and saying in decisions. But it's a really challenging area of the law because you got to marshal the facts in the best way that you can under the circumstances that you can for your client. But you are playing with what I would call significant stakes, i.e., Does the payor have to pay spousal support in Ontario law or not? And in a lot of cases, things aren't going to be perfectly clear. There's going to be some changes. And just recently, two Court of Appeal decisions came down on the same day a few months ago, and one decision said one thing and recognized the foreign divorce, and the other case didn't recognize the foreign divorce. Both on the same day, different judges, but same Ontario Court of Appeal. So that gives you some nervousness as a lawyer from those decisions, in that, well, they're different positions taken by the Court of Appeal.
It's exactly what Andrew said. This area of law, at least in my experience, and Andrew, I'm sure you can agree, is it's so fact specific. So that two very different cases that ultimately are trying to decide similar things, potentially even within the same foreign jurisdiction, could be decided very, very differently depending on the facts of the case. And one of the reasons for that is this real and substantial connection test. Because it's like you said, it's not an exhaustive list, it's a weighing of factors of, when we look at holistically, did these parties have a real and substantial connection to that jurisdiction?
And there's going to be easy cases. The easy case is going to be when they were living as husband and wife in the foreign jurisdiction, and one person got on a plane and ran to Ontario and commences a court application in Ontario. That's an easy one, because clearly the last habitual residence of the parties was that foreign jurisdiction. That's the right jurisdiction. And the person that's coming to Ontario is really the foreign jurisdiction shopper in that case. So it brings up some interesting issues. Now, there are a few other issues that flow. We've been talking about spousal support, and the reason why we're focused on spousal support is because that's the one that you're prohibited from making claims if you've obtained that foreign divorce. For example, the issue of division of property. That flows on a different test. And what is the test, Lauren?
The test there is the jurisdiction where the parties had their last common habitual residence. So when we're talking about property issues, we're looking under the Family Law Act. But the other thing to keep in mind is, for married spouses, the limitation period for equalization is 6 years from the date of separation or 2 years from the date of a divorce order. So if a court recognizes a valid foreign divorce order, your time period to claim equalization, if you even meet the jurisdiction in Ontario, has now just potentially been shortened, depending at what point you obtained that order and whether or not it's valid. And the other thing that we look at, Andrew, is sometimes when there's a support order made in a foreign jurisdiction, we now have to consider the applicability of the Interjurisdictional Support Orders Act to determine whether or not that support order is actually enforceable or not in Ontario. So there's a whole array of, I agree with you, it's more than just spousal support. I think the reason we focus on is I don't know that everyone is quite attuned to the fact that you could be giving up a lot of potential spousal support money simply by getting a divorce in a foreign jurisdiction. And it may be what you want in that moment to get a quicker divorce, but it could have catastrophic consequences down the road.
Now, the other thing that lawyers will do as a mistake, and I've seen it before and scratched my head out of frustration, is the scenario where the couple decides, we're going to go get that foreign divorce. So you're acting for the payor. He or she goes and gets the divorce in that other jurisdiction, and they're the payor. They would be the one who's going to pay support. And the recipient spouse starts an action in Ontario, and there's issues as to whether this matters or doesn't matter, but there's something called attornment and attorning to a jurisdiction. And maybe the better scenario to frame the question would be the scenario where the parties were residing in a different jurisdiction. One person came here, they commence in Ontario, and one side should say, I don't want to be in Ontario. How would you say it? What does that mean?
So essentially, it's very, very important is that if you don't, it's exactly what you said, Andrew. We talk about not attorning to the jurisdiction, which is basically when a matter is in court, if you are wanting to challenge the jurisdiction. So let's use Ontario, for example. You're wanting to challenge that Ontario does not have jurisdiction over the issues arising out of the breakdown of the relationship because another jurisdiction in your mind should have jurisdiction. If you do anything in court other than challenge the jurisdiction, you're leaving yourself open to a potential argument of you having attorned or agreed to Ontario having jurisdiction. So for example, you can't say, well, I'm going to talk about the parenting issues in Ontario, but Ontario doesn't have jurisdiction about anything. about anything else. In theory, you could, but if you're returning to that jurisdiction and not challenging it and just kind of following what the laws are there in Ontario, following through with the court process, potentially a court could determine that even if they otherwise would not have had jurisdiction, they could argue that the person returned to Ontario having jurisdiction such that they would exercise jurisdiction for that matter. So it's very, very important if you're in court and wanting to challenge jurisdiction, at least in Ontario, that you're making it very clear that your only participation is because you can't not participate, right, in court. If you don't participate, you leave yourself at risk of being noted in default and the other side proceeding uncontested, which has its own consequences and problems that come with it. So, for example, you would do your answer and ask for nothing else other than for the action to be dismissed because there's no jurisdiction, and outline your position about why Ontario does not have jurisdiction. But it's important not to take any steps to return to that jurisdiction. Otherwise, you're at risk of that jurisdiction taking jurisdiction over the matter.
And the part that really requires a lawyer that makes you appreciate the piece of being familiar with this topic is understanding that fine line between saying I'm not attorney and responding in terms of dealing with the jurisdictional issues versus getting into the fray of what the litigation is about. Because a court could end up saying, well, we shouldn't have jurisdiction, but you accepted Ontario.
Yes.
And just picture if you're from a jurisdiction where you might not pay any support or it would be very little, and now you've returned to Ontario, it can have tremendous differences in what's going to happen to you going forward. So I say that, and I echo what Lauren is saying, because this is an area, there's a lot of information we give out on these Ask Andrew shows, and I know a lot of self-rep people watch these shows and take this information down, and we partly do this as a public service so that people have more understanding so they can help themselves. We're also here to help you, of course, if you want to hire us. But this is one of the times I would say it is absolutely critical that you don't do this on your own. It's a high probability that it will be fatal. And it's a high probability that you're going to make mistakes that may have consequences that flow for the rest of your life or for a very large part of your adult life. So it's really important to have a lawyer, and not just any family law lawyer, not just any lawyer. The question asked is to any lawyer you interview, if it's at our firm, whether it's one of our lawyers like Lauren, and there's others that are familiar with it, or we have lawyers here who are familiar with it, we'll either help that lawyer or we'll do it ourselves. But we have a lot of familiarity with these issues. We've argued these cases before. We continue to argue these cases. And it's important, if you're not going to us, that you go to another law firm that is familiar. Don't be sold by somebody saying, oh yeah, not a problem. Because there's so many times I have had people walk into my office. I know you've seen it too, Lauren. And you scratch your head because it's, oh my God, I can't believe the advice that was just given. And there's an Ontario Family Law Facebook app page that a lot of us are on. And sometimes you see lawyers talking about it and asking questions, and it just leaves you shaking your head because you can't believe that somebody would actually be putting out that advice. But you can see that they've given the advice. That's their thoughts. And I really say that to people because the consequences here are so significant that if a mistake is made, there's a high probability it can never be fixed. There's a lot of things we can do to fix somebody else's mistake. But if you torn where you shouldn't have torn, we can't fix it. If you allow a foreign divorce to go through and it goes through and they dotted their I's and crossed their T's, we can't fix it. So these are things that will have lifetime consequences for everyone. Now, I do note that I see we're out of time now. Lauren, I want to thank you because you gave a lot of really informative information for our viewers. And to our viewers, I hope that they have at least a handle to recognize the issues of a foreign divorce. If they see it, maybe they have a close friend or family members going through it, I urge you to contact us for a free consultation. You can visit our website at separation.ca. And the next Ask Andrew show will be on Tuesday, May 28th at 12 o'clock p.m. If you have any requests or future show ideas, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.